Fiona de Londras, and chairing this evening's debate is Sarah McDonald. Sarah is an award-winning freelance journalist specialising in religious affairs. She writes for the Irish Independent as well as the UK international weekly The Tablet, and she's made documentaries for RTE Radio, and her background is in international relations, history and archaeology. I'm going to hand you over to Sarah now. Thank you.
Good evening, everybody, and I just wanted to thank you so much for your patience. You know, sometimes things don't run as smoothly as you want, and we all understand with traffic and all the rest. So look, this evening we're here. I'm welcoming you to the Woodlands Hotel for this public debate on the 8th Amendment and the referendum on the 25th of May. We're delighted to have two such high-profile speakers on behalf of the two sides of the debate. They will present their arguments on why the 8th Amendment should either be retained or repealed in the referendum. Irish citizens vote on the issue of abortion on May 25th, as we all know, and they will be asked whether or not to delete Article 43.3 of the Constitution, known as the 8th Amendment, and to replace it with a new article allowing the Oireachtas to legislate on the issue. Now, Article 43.3 states that the state acknowledges the right to life of the unborn and, with due regard to the equal right of the mother, guarantees in its laws to respect and, as far as practicable, by its laws to defend and vindicate that right. In the event of a yes vote, Article 43.3 would be removed and replaced with an enabling provision, and that would state that the provision may be made by law for the regulation of termination of pregnancy. So to discuss these issues, the 8th Amendment and all these ancillary issues, we have Fiona de Londras, who's a Professor of Global Legal Studies at the University of Birmingham. She's a specialist in comparative constitutional law, and she gave evidence to the Joint Oireachtas Committee on the 8th Amendment. She recently published a book with Mairead Enright, Repealing the 8th, Reforming Irish Abortion Law. And she's founder of the legal information website, www.abouttheeighth.com. And she says it's designed to empower voters of all persuasions with accurate, clear and accessible answers to legal questions about the referendum. Our other speaker this evening is Caroline Simons, and she's a solicitor and legal consultant to the Pro-Life campaign. She's been interviewed on the pro-life position, which advocates retention of the 8th Amendment. And she's been interviewed on numerous occasions by top journalists and participated in major television and radio programmes such as The Late Late Show, Prime Time, Claire Byrne Live, The Tonight Show, Today with Sean O'Rourke, Late Debate and Drive Time. She's also spoken at many rallies throughout the country. So just a couple of minutes ago, we tossed a coin to decide who should speak first. And the outcome of that was Fiona de Londras will speak first, and then she'll be followed by Caroline. And just to give you a sense of the format for this evening, the speakers each will speak for 20 minutes. And then after that, they'll get a chance to respond to each other and to put questions to each other. So that'll take about another 10 minutes each. And then after that, you, the audience, will get a chance to put your questions to the speakers. So there's just some little housekeeping points I just want to make before we launch into the debate. I'd just like to highlight that, you know, we're all here to get a chance to hear the speakers and to inform ourselves. So this debate is taking place for the sake of informing the public like you and me about this important issue. And we can only be informed if you allow the speakers to conduct their business peacefully and in conditions that allow them to express their thought and get whatever they want to say across. So we don't really want people interrupting from the floor during the course of the presentations. I would also ask you to refrain from any heckling or, you know, abusive language or getting overheated. It's much more informative if we just let, you know, make our points concisely to the point. And to say to people, if you abuse those housekeeping rules, we'll have to take the microphone from you. Or if you decide to take, you know, too long to make your point, we'll whip the microphone back if that's okay. And just then, finally, just to say to you, in the event of fire, your exits are on both sides here, okay? So I now call on Fiona to open the debate. Thank you very much.
Thank you very much for coming. In spite of the fact that I'm based in Birmingham and I have a relatively exotic sounding name, I'm from Tipperary and spent many relatively happy summers going to Colóiste and Aringa when I was a child, so it's great to be back in Waterford to be here for what I think is an important occasion, as Sarah said, to talk about the upcoming referendum, to share our thoughts and perspectives, to ask questions and hopefully to discuss this in a productive and effective way. I want to start by making three things clear about my own position. The first one is I'm not here to change anybody's mind. If you have your mind made up and you believe that the way that you intend to vote is in line with what you think is best, I completely appreciate and respect that, and I think that that is what you should do. The second point is that what I am here to do is to try and provide information, to try and provide an argument and a set of information, and that I will commit to you that I'm not here to frighten you, I'm not here to misrepresent anything, and I'm not here and I'm not going to tell any lies. Because the third point that I want to make at the start is that in my view as an educator, information is power. The point about information is that it should empower us to make the right decisions for us, for our lives, in life and in the ballot box. And so I'm here in that spirit to offer information, of course in the form of an argument, but the factual elements that I will offer in support of my argument are accurate and verifiable. And that's the spirit in which I want to proceed. We don't have great light here, so I'm going to end up with, like I have bifocals or something. Sorry. So, that argument that I want to make over, I think, about the next 18 minutes, if I have my timing right, has four parts to it. The first part is that the Eighth Amendment doesn't work. The second part is that a better law is possible. The third part is that legislation is an appropriate way to regulate access to abortion. And the fourth part is that the proposals that have been published by the government, in my view, strike a fair balance. And I'm going to use the word balance quite a few times, and I want to be pretty clear at the start about what I'm going to say is being balanced. There is a value to the protection and promotion of unborn or fetal life. I don't disagree with that. There is also a value to the protection of the life and the health of pregnant people. And my view is that our aspiration should be to find a way to strike those two things in balance, both of which I think are part of our collective common good. And so in my view, the correct balance, or the better balance at least, no balance is ever perfect, the better balance at least, is one that tries to support pregnancy and parenting and uses the law to create support rather than using the law to compel. So let me start with the first part. The Eighth Amendment doesn't work. I really think that's true no matter what perspective you come from. If one believes that the Eighth Amendment exists to protect the unborn, to protect fetal life, it doesn't work. We know that abortion exists. Abortion has always existed. People in Ireland accessed abortion in 1983. People in Ireland access abortion now. If our aspiration underpinning the Eighth Amendment is to prevent abortion, then it doesn't work on its own terms. Secondly, I don't think it works because I don't think it protects the health of pregnant women. The aspiration of the Eighth Amendment, what the provision says is that the state recognises the equal rights to life of the unborn and the pregnant woman, and will, to the extent practicable, defend and vindicate, in fact must defend and vindicate, fetal life. And what that does is it sets a very low bar for what we consider constitutionally successful pregnancy. Because constitutionally successful pregnancy is pregnancy where a woman is still alive at the end of it. I don't think that's good enough. I think we should aspire to pregnancy where hopefully a woman is both alive and healthy at the end of it. And if she has suffered from, let's say, harm to her health, that she has done that voluntarily. So that she has had conversations with her doctors about the risks that might arise in a particular pregnancy, and she has decided to take those risks, as the vast majority of women do in pregnancy every day. But I think as a sign of constitutional success, the fact that a woman is alive and the fact that a baby is born alive is not, for me as an Irish woman, good enough. So I think we can set a better standard. Did that mean something? No? Sorry, I thought, God, have I already spent 18 minutes? Sorry. So I think we can do better than that. We can set a better standard. And the third part of it is, of that argument that the eighth doesn't work, is that I don't believe the eighth reckons with the realities of life. And I'm a pragmatist. I think that law needs to be designed to reckon with the reality of life. And it doesn't. Not only does it not reckon with the fact that thousands of women in Ireland have abortions every year, but it also doesn't properly deal with the realities of who has abortions, when, why, in what kinds of circumstances. More than half the people who have abortions have children at home. The majority are on contraception and have experienced a contraceptive failure. Like, what we think we know about when and how people make decisions about abortion is not always accurate. There's no two cases are the same. And I think the law needs to be able to help us to regulate real life and not to regulate some kind of fantasy world that doesn't exist in reality. So in my view, the Eighth Amendment, as a matter of practicality, pragmatism and law, doesn't work. But I do think that we can make a better law. This is my second point, that better law is possible, that we can hope for better, and we can strike a better balance between those two parts of the common good I already mentioned, the protection of unborn life, or fetal life, and the protection of the life and health of pregnant women. It is really important here to remember that the Eighth Amendment is not only about abortion. It is about health care during pregnancy. It is about what we oblige the state to do and what we oblige women to bear, instead of what we enable women to decide whether they will bear or not in terms of health risk. So, for example, even though we all, as competent adults, so I'm going to assume we're all here legally competent adults, can ordinarily refuse consent to medical treatment, that's not the case always in pregnancy. And in fact, the nature of the fact that what we're doing here is having a constitutional right as the mechanism of protecting fetal life is to say that we create almost the inevitability that we will have litigation about whether or not a woman can make a certain decision in her pregnancy. That sometimes doctors will not know what they are and what they're not allowed to do, and their hospital legal departments will say, we need to go to the High Court. We create a kind of adversarial environment in which to practice maternal health care and in which to experience pregnancy. And I also don't think that that is workable or favourable or preferable. I think pregnancy should be a happy, healthy, joyful, emancipatory experience. I think it should be voluntary and consensual. And I don't think the Eighth Amendment allows us to do that. And by the way, I think most of us would agree that in the ideal world, pregnancies would be all of those things. Wherever we stand on the Eighth Amendment, I think we would all agree that that would be good, right, in a basic sense, if pregnancy were all of those things. So I think that we are capable of making a better law than the Eighth Amendment. I think also, and I am acutely aware, that many people are uncomfortable about or concerned about the possibility that if we do repeal the Eighth Amendment, something that is represented sometimes as an English-style abortion law would be introduced. I have three things to say to that. The third one I'm going to expand on later, and that is that the proposals are not comparable to the Abortion Act of 1967, but put that on a post-it, I'm going to come back to it. The other two things I would say is that right now, English abortion law is Irish abortion law. For more than 3,000 women every year, English abortion law is Irish abortion law. The second thing, rolling on from that, is if we don't think that the kind of abortion law that exists in England is right for our country, then we should repeal the Eighth Amendment and make Irish abortion law. That's my view. If we really are uncomfortable with that law, we should remind ourselves the Constitution doesn't deal with real life. Abortion is real life. Most women who access abortion in Ireland access it under the Abortion Act of 1967. So to all intents and purposes, that law, which we don't want to operate here, is the law that operates here. That's the law that people get abortions under. So I think a better balance is possible. I happen to think it would be better also, all round, if we did have a better balance, a more balanced law. And I also think, to move on to my third point, that legislation is the appropriate way to do this. Now, this is the constitution legislation debate that I know a lot of people are worried about. If we remove the 8th Amendment, the unborn will not have constitutional rights. That is true. The Supreme Court has said that in the M case, but the Supreme Court also said the protection of fetal life, of unborn life, is part of the common good, and the state is entitled to legislate in pursuit of the common good. What does that mean? Well, it means, as with anything, almost all constitutional rights are, we call, qualified or limited, so the state can interfere with them, right? But to do so lawfully, the state has to have a legitimate objective. It has to be acting in pursuit of the common good. So first of all, it means that we can legislate. But the first point to make is that to say we would regulate abortion through legislation does not mean that we would not have any protection of fetal life. I don't think anybody here believes that the only reason we protect the unborn in this country is because the Constitution tells us we have to. I don't believe that. I believe we do it because we think it's in the common good. I believe we expect our politicians to do it. But what we want, those of us advocating a yes vote, is for it to be done in a more balanced way. That's all. So why is legislation appropriate? Beyond the fact that you can still strike a balance within a legislative framework. Second reason I think legislation is appropriate here, is that it would put us back into this kind of default position about accountability. You know, it's a funny thing. Usually we think it's a good thing that the politicians who are accountable to us are the ones who make decisions about law. Because democratic accountability is what underpins our constitutional democracy. Now, when we regulate abortion in the Constitution, there's no democratic accountability. We can't ask for a referendum if we think the balance is wrong. The Oireachtas has to give it to us. That's Article 46 of the Constitution, right? A referendum has to be moved by a bill of the Houses of the Oireachtas. But if we legislate for abortion, and if politicians don't strike the balance you think is right, you vote them out. That's how democracy always works. And ordinarily our default position is that that is preferable, that is good. That we have a close relationship of accountability between the lawmaker, the governor and the governed. That's usually what we think is better. If we repealed the 8th Amendment, we would return to that default position of close democratic accountability. So I think that that would be preferable. And the final point here on the appropriateness of legislation is that the possibility that somebody might take a constitutional challenge to any new law is nothing to be afraid of. That's how our Constitution works. That's how our Constitution works. That's how it's supposed to work. The Oireachtas says we think this is the balance. If it infringes on us, we go to a court and we ask the court if the Oireachtas has got it right. And the court says it has or it hasn't. If you have a piece of law and the court thinks some of the balance is right and some of it isn't, they can strike down just a part of that law, for example. But the likelihood is, in my view at least, that if we passed a law like the law that the government has proposed, it would actually pass the constitutional test. A couple of reasons. I've already explained the proportionality idea. Our rights are not absolute. The state can infringe on them. They have to have a legitimate objective. They have to have a legitimate objective, and they have to interfere in a proportionate way. I think that the proposed law does that. But also, every piece of law that comes through the Oireachtas enjoys what we call the presumption of constitutionality. That means, if I go into court to challenge it, it's up to me to prove it's unconstitutional. The starting presumption on the part of the court is that it's constitutional, because, of course, the court says the Oireachtas' job is to legislate in line with the Constitution. So we start with the presumption that they've done that. And it's a heavy burden to displace to show otherwise. And in areas that are socially divisive, it is well-established constitutional law that presumption is heavier in favour of the legislation than in other areas, because the courts recognise, like we all do, that democratic accountability point. The Parliament has a higher degree of legitimacy in deciding on socially divisive issues than the courts do. So there would be a very heavy burden to displace, to have the proposed law, if it became the law, found unconstitutional. And I think based on precedent, based on experience in other countries, the likelihood is that it would be constitutional. In fact, I've tried very hard to think of a case that might defeat it, and I can't. And I have tried very hard. So it brings me on to my fourth point, which I'll try to do in about 3 minutes, which is that the proposals from the government strike a fair balance, introducing regulated and limited abortion. Now let me deal with this in a couple of ways. First of all, the proposed law divides pregnancy into these two phases, up to 12 weeks and after 12 weeks, right? Up to 12 weeks, you will not have to explain to anyone why you're having an abortion, but that doesn't mean abortion will be unlimited or unregulated. You'd have to go to a doctor. In some, not very many, but in some countries you can go into a pharmacy and just buy the abortion pill. That's not proposed here. You have to go to a doctor. The doctor will have to certify a legal certificate that you're within 12 weeks from the first day of your last period, which is how pregnancy is measured, this 12-week LMP it's called, since last menstrual period. And then you'll have to wait 3 days. And waiting 3 days is important. It's part of the balance. Because the idea there is to say at that stage a woman has legal certainty. She knows that if she still wants to in 3 days' time, she can have an abortion. And during those 3 days, she doesn't have to worry about practicalities, about flights, about legality, about anything. She can just think about what is right. What is the right decision for her? The right decision for her family. She can talk to her partner. She can talk to her doctor. She can talk to her priest, her counsellor or advisor. She has 3 days of legal certainty. And by the way, if the 3 days run out, that's okay too. You know, you're not going to lose it on day 4. Right? So it actually is designed to put in place support for reflective decision making in that early phase of pregnancy, up to 12 weeks. I'm not going to rehearse here because I think you have already heard the arguments for why there should be a protected period, that there is no other way really to deal with the reality of cases like rape victims, but if people want to talk more about that, we can do so in questions and answers. I'm very happy to do that. There is also a broader point here that, you know, I think as a matter of principle, there should be a period of time in early pregnancy where women can make a considered and supported decision about their pregnancy. And that would be enabled by the protected period. After that, pregnancy will be available only in very limited circumstances. And, you know, it truly, I'm not making this up, it truly is limited. 2 doctors, one of whom has to be an obstetrician, so that's a level of senior oversight that we don't find in some other jurisdictions, will have to certify that there's a risk to the life of the pregnant woman or a serious risk to her health. Will it be both physical and mental health? Yes. Is that something to worry about? Sorry, but I don't think so. Mental ill health is ill health. Mental health is health. Doctors are trained to assess health and assess risk. They do it every day. I mean, I don't understand the argument that we might think that the same doctors who we believe can identify a real and substantial risk to life and differentiate it from an ordinary risk to life can't differentiate a serious risk to health from an ordinary risk to health. It's just what we're asking them to do already. I'm going to finish. After viability, abortion will be illegal, it will be a crime, where in cases of a fatal diagnosis for the fetus, it will be possible to bring a pregnancy to an end at any point. I think we all agree abortion isn't quite the right word for that. We can come back to it in questions and answers. Sorry. See, now it's all going to disappear. Oh, very nice. Okay, so those are my 4 points in favour of repeal. Thank you.
Or live streaming, can you tell us where you're live streaming to so that everybody can log in?
It's to the Rise and Repeal to Waterford Together for Yes page on Facebook.
What page? Right to Repeal?
Rise and Repeal. Waterford Together for Yes, Rise and Repeal.
Okay, so if everybody looks at Waterford Together for Yes, Rise and Repeal page, you'll be able to see the debate online. Thank you for that. And it's on Twitter, thanks very much.
Okay, so next up we have Caroline Simons, and she'll talk for 20 minutes.
Microphone is good, because the first thing you're going to see is I don't have much of a voice. I didn't think I'd make it here, but I couldn't let you all down. Thank you very much for coming. I see the front two rows there are full of people campaigning for Repeal. I welcome you very much as well. We always, so far, debating and speaking to their own debates are few and far between, so we welcome this. Pre-1983. What will be the protection given to the baby? Will there be anything left in the Constitution for it? And as Fiona said, it's been made very clear by the Supreme Court in the M decision that the only constitutional protection the unborn baby has is actually in Article 43.3, the 8th Amendment. So if that goes, there won't be any constitutional protection. And what will the impact of that be, and how will legislation or some kind of legislative protection in the interest of the common good that Fiona has described, what kind of protection might weigh in the balance, or is there any balance to be weighed at all, where the mother is then the only person with any constitutional rights to be protected? But I must say I will take my cue from Professor Jerry White, who's a constitutional law professor at Trinity, who spoke about this in the paper some time ago and has revisited his opinion since the draft heads of bill have been published. And he says that in 1983 the Constitution was silent on abortion because the people had not spoken. If there is a repeal in 2012, the people will have decided to remove all constitutional protection for the unborn. And he says that this, in his opinion, would mean that the Constitution could only be construed now as protecting the constitutional rights of the mother to autonomy, privacy and bodily integrity, and that it would be constitutionally impossible to legislate for a restrictive abortion regime. Now that's one constitutional law professor, and you may choose not to listen or to agree with what he has to say. One of Fiona's colleagues, Dr. Mairead Enright, has expressed her understanding of what the position would be if the 8th Amendment is removed or repealed by the people on the 25th of May in exactly the same terms. She said that if the 8th Amendment is repealed, we could have, and I'm quoting directly from her, interim legislation as a stopgap on the way to light touch or almost no regulation at all. And that is a common understanding between the legal experts on both sides. Whatever restrictions are put in place will be illusory, because the mother in that situation will have all of the constitutional rights and she will be entitled to abortion on the terms that she looks for it eventually. And in fact, when we saw the method of application in practice of the 2013 legislation, we saw a case in which the HSE indicated that it was one of the proper ways of terminating pregnancy under the 2013 legislation could be by caesarean section, because what we were dealing with in that legislation was terminations of pregnancy, not terminations of unborn life. And the response from Fiona and Mairead's group to that was that in no circumstances should any medical process designed to prolong pregnancy in the fetal interest be substituted for, or designed to result in a live birth, be substituted for abortion. So we see there are two very different things that we're looking for when we're looking at the Constitution. I will come back to the UK, but I'm not particularly interested in it this evening. I'm more interested to speak to you about not even the bill, but about what it is we're voting on. We are not voting on this bill, the draft heads of bill that was produced by the government in March. On the 29th of January, when Leo Varadkar stood on the platform with the Minister for Health, Simon Harris, and the Minister for Children, Catherine Zappone, he said there were no guarantees about this bill, and he's correct about that, of course, because it will have to be debated, go through the debating process at the Oireachtas, it may be amended, what we've been given may bear little resemblance to what we get at the end, and in any event, you are not being asked to vote on it. The question that you are being asked is, do you agree that the 8th Amendment to the Constitution should be removed and that an insertion should be made, the 36th Amendment, giving all power to the Oireachtas to make laws in relation to abortion? That's all you're being asked. Will you give all powers to the Oireachtas? Looking at the policy paper that was produced, there was two documents produced in March. There was the policy paper on the 8th of March, and then on the 27th they produced the general scheme, the draft heads. And to be clear what's there, Policy 9 in the draft, in the policy scheme says that termination of pregnancy for a fetal condition likely to lead to death before or shortly after birth or for maternal health should not have a gestational limit in the general scheme. That means no time limits. Let's look at the general scheme and see what the general scheme is designed to introduce. First of all, in relation to the general scheme, I think it gave Simon Coveney such a fright that he immediately wanted to restrict the Oireachtas's power to amend it, which of course would have been unconstitutional. He was told he couldn't do. Leo Varadkar himself on the 10th of January said that the current proposal may be a step too far, and I hope this evening to explain to you why I believe that it is. If you look at the definition section, in the 2013 legislation it says it shall remain an offence to deliberately destroy unborn human life. In this, and the medical procedures which are permitted under the current law, the 2013 legislation, are medical procedures in the course of which, or as a result of which, unborn human life may be ended. Okay? In this it says, termination of pregnancy means a medical procedure which is intended to end the life of the fetus. Not to end the pregnancy to save a mum's life, to end the life of the fetus. It's a medical procedure intended to end the life of the fetus. Now, the understanding that we were given in 2013 of current obstetric practice then and since the 2013 Act was well summarised by Rona Mahoney, the Master of the National Maternity Hospital, when in her evidence in January 2013 to the Oireachtas Health Committee, she said, "We must vindicate the life of the fetus where it is practicable. All efforts are exhausted within the medical margins of safety to prolong pregnancy in the fetal interest." Safety, the mother was not to be put at risk. And then she said, "We do not destroy or kill fetuses." The group that Fiona is a member of said, "In no circumstances would it be appropriate to substitute medical procedures to prolong pregnancy or result in live birth for abortion." So we are talking about a completely different vision for maternal health care in this country. Between 2013 and 2017, at least 7 terminations of pregnancy occurred on the basis of a mother's threat of suicide. Last year, a panel of doctors established under the Protection of Life During Pregnancy Act approved a late-term termination of pregnancy where the medical team caring for that patient deemed her not to be suicidal. In that case, the young girl in fact, was assessed over 12 days by 5 psychiatrists who found she was not suicidal, and 2 signed off on her discharge at final examination. 3 days before she was discharged, however, in the context of an assessment for a termination under the Protection of Life During Pregnancy assessment, 2 said she was suicidal and entitled to termination at 25 weeks of pregnancy. What happened, in fact, in that case was she was delivered at 28 weeks and that baby is in the family home with his mother or her mother. There is a bit of concern about how the Act actually operates. It has, we know, in at least one case resulted in one baby having been delivered very prematurely, having a severe, lifelong adverse result. And it's unclear in the other statistics that we've been given whether the babies got into NICUs, into neonatal intensive care units, and are living. For instance, my first child, who was delivered to save my life very prematurely and spent a few months in a neonatal intensive care unit, would have, under the scheme of reporting that was established in the 2013 Act, she would count as a termination of pregnancy, even though she's alive and walking around today. So the kind of reporting, I know I can see some wrinkling their eyes, it's actually true. The kind of reporting that we're getting is really inadequate. There isn't a sufficient breakdown. We don't know how many babies actually were given care afterwards and how many died, just to make that clear to you. So I think that I'm going to go from there just to look, that's looking at the Act. I should also actually look at the question of late-term abortions. We were told by Simon Harris, at least when he was making his presentation to the Senate, he said that in effect late-term abortions would be illegal under this heads of bill, and that was also expressed, I think, by the Taoiseach. Looking at it, the only time limits that are there aren't, this isn't in 2 phases as Fiona has set out. The actual pregnancy is in 3 phases under this draft heads of bill. We're talking about the first 12 weeks when for any reason a woman may have an abortion, and then up to viability, and then beyond viability. So it is the case that abortions can be permitted under the heads of bill right up to birth, without any kind of gestation or time limit. And that raises questions. That's not something the government really wants us to be thinking about, because, for instance, a woman presents at 22 weeks pregnant, and she is allowed, under the terms of this bill, to have a termination. And she does a medical termination. You can have medical terminations with pills, in fact, throughout the 3 trimesters of pregnancy. So she has a medical termination, and the uterus empties, the fetus and the placenta come out, and the fetus is moving. What are you going to do with that fetus? an interesting question to ask. In England, we know that in 2005, 66 babies survived that kind of a termination. We know that in a 10-year period in Canada, over 460 did. And the Royal College of Obstetrics and Gynecologists then issued a recommendation that once you're 21 weeks and 6 days gestation, that the fetus has to be injected so that it dies, and then when the abortion is carried out, you don't have a live birth. These are the kind of questions we're going to have to think about. So just to say that to you, it is not true to say that there cannot be late-term abortions under this. There are at least 3 situations in which this bill envisages that abortions can take place with no time limit. So that should be hit on the head as well. I think, as we were talking about these things too, myths and truths, I'm holding in my hand the current edition of Hot Press, and there's an interview in it, Repeal the 8th, Dr. Boylan skewers the pro-life lies. I'd like to skewer some of his misinformation. He was asked a question here. Professor Eamon McGuinness claimed no woman had died as a result of the 8th Amendment. Well, now this is very interesting to me, because if you go back to look, I really do not want women to die. I have always said, having had the benefit of a Savita-type situation that was avoided because I was properly monitored in my second pregnancy, and then the first one where I had to be delivered to save my life, I'm enormously grateful to the emergency care people who looked after me. Savita was neglected, there's no doubt about it, and it does seem, there was a negligence case afterwards, etc. Whatever misunderstanding there may or may not have been around the 8th Amendment, that Peter Boylan did say in an interview recently with Eamon Dunphy has been clarified by the 2013 legislation. But in 2013, obstetricians gave expert evidence to the Oireachtas Health Committee, and they were asked very specifically, have you ever withheld medical treatment from a woman when she was pregnant because of the legislation? That question was asked of Rona Mahoney, the master of the National Maternity Hospital. It was asked of Sam Coulter-Smith, who was the master of, is it the maternity? Fiona, can you help me here? I don't know. Anyway, he's a master of one of the other Dublin hospitals. She was asked of Mary McCaffrey, who was an obstetrician in Kerry Hospital, and it was asked of Nuala McAuliffe, who was the head at the time of the Institute of Obstetricians and Gynecologists. Each one of them, without exception, said they were not aware of any deaths that had taken place as a result of the law. They had not refused a woman any treatment that she needed, and they were not aware of any of their colleagues who had done so either. So I'm wondering if since 2013 there have been deaths, because if that is the case, they haven't appeared in the confidential inquiry into deaths in England, Wales and Ireland, which has been published, and from which in December last Dr. Boylan said that we could take great reassurance that women are looked after well here, that we have fewer women suffering maternal mortality, or he said maternal morbidity, serious maternal morbidity. Now that means health, ladies and gentlemen. We do not have any worse health outcomes for mothers without abortion in Ireland than they have in England. In fact, we actually score better on that. Coming back though to the assertions that are in this Hot Press interview, the questioner here asked, Professor Eamon McGuinness claimed no woman has died as a result of the 8th Amendment. Now, Dr. Boylan was asked this question as well in October, I think, before the Oireachtas Committee, and apart from Savita Halappanavar, who he continues to say did die because of the 8th Amendment, although the 3 independent inquiries did not find that they were the causes of her death, he couldn't think of anybody else off the top of his head, unquote. But in this interview, he names Michelle Hart and Sheila Hodgers, Miss P and Savita again. So just to say to you, in relation to those cases, can we all absolutely agree that Savita Halappanavar was disgracefully looked after? There's no doubt about that. Unfortunate woman at a weekend in a hospital. We all know that's not a great idea. We all know that the standards that were supposed to be set in play in maternity units in relation to sepsis after the death that had happened in another Irish hospital were not in operation. And she died. And we would hope that this would never happen again. We do know that fewer women die of sepsis in pregnancy in Ireland than do in the UK, where abortion is freely available on demand. Michelle Hart was a woman who was suffering for about 10 years, 9 or 10 years, and being treated for melanoma. She was being treated in Cork University Hospital. She was very, very ill, to such a degree that she wanted to be admitted to a clinical trial for an unapproved drug, which you wouldn't be allowed to do unless you were in extremis. She was not allowed onto that trial because she was pregnant. Her obstetrician, according to the Irish Times, was willing to do a termination. but the hospital didn't think it was necessary because at that point they said her life wasn't at risk, and also she was going to be afforded whatever cancer treatment they always give. And so she went to England, had the termination, came back, and a number of months later she died here. The point that I must say to you about that is the 8th Amendment in the Irish law was not what kept her from access to the clinical trial. It was the regulations around clinical trials at the time. Historically, women, not even pregnant women, but women have not been part of clinical trials, which is really wrong. I'm sure we will all agree on that. And women largely take an awful lot of medicines blind that have never been tested on women, because women, by the patriarchal pharmaceutical industry, were seen as vulnerable, probably also reflecting the fact that their insurers didn't want to see any claims against them for adverse effects of the drugs on themselves or their babies. However, that is changing and has changed to quite a degree, and on the 5th of April this year, the FDA has brought in new guidelines which suggest that women very definitely should be part of these clinical trials, and pregnant women most certainly should be. That is changing, and quite a lot of the new regulatory guidelines that have come out are saying that, but the 8th Amendment has nothing to do with it. Sheila Hodgers, another absolutely terrifyingly awful case, is the only way to describe it. The description of her, that her husband gave in the papers at the time was shocking. She died before the vote had even taken place on the 8th Amendment. So again, not something to do with the 8th Amendment. And then finally, Miss P's case. In Miss P's case, Miss P was a woman who, at 15 weeks pregnant, was declared brain dead and was on life support. Her doctor seemed to be happy to continue with her on life support, and her father took a case to the High Court looking to have the somatic support, which is life support, removed from her. And the upshot of the case was that the 8th Amendment did not prevent the High Court from ordering that the life support should be discontinued. Now, yes, the application was made to the court because there was a baby that was living and something had to be decided. But I can tell you, at roughly the year beforehand, there was a similar case in America, Marlene Munoz, same time, 15 weeks pregnant, and her husband brought a similar case to the courts there. And again, the life support was removed. And unlike those two cases, also the year before Miss P's case, in the United Arab Emirates and in Hungary, there were two cases where women were declared brain dead at 16 and 15 weeks respectively. And in those cases, the uterine environment was much more stable than Miss P's was. She was being maintained well, the mothers were being maintained well, the families were happy to continue with the treatment, and 2 healthy babies were delivered at 28 and I think 32 weeks after 96, I think, and 110 days of life support. Extraordinary. But the point I want to go out viciously to keep alive, and that's the law. They don't have to keep people alive in these situations, so I'd just like to say that to you. Now, we have world-leading care for pregnant women. We know it's one of the safest countries in the world for expectant mothers. We've seen the new statistics out in December. We have heard numbers of doctors saying that they have never withheld treatment. Some of these doctors are now saying they'd like the 8th Amendment to go. And so I ask, when I see these statements, how can you say that you cannot practice medicine adequately with the law that is there, when in fact you've been able to do so, and you've said, in 2013 to the Oireachtas that you've never withheld treatment and you don't know anybody else who has done so. And the most important thing I want to say to all of you today, I think, is this. This is not a restrictive bill, and this is not a restrictive measure. This is an extremely serious responsibility that each one of you have, one by one by one by one, as you go into the ballot box. If you are not happy with abortion on demand, and most abortions will take place, as we know, in the first 12 weeks, and yes, they will deal with disability, please don't believe that they won't. Why am I saying this? I'm saying this because we must look at the reality. This year, the National Health Service in England is making available for free to women who are at risk blood tests that can be done at 9 and 10 weeks that will tell them if their babies have got Down syndrome, Edwards syndrome, Patau syndrome. And yes, at the moment, these tests have to be further confirmed with other tests done at 12 and 14 weeks. But these tests are currently made, not yet commercially available, that are diagnostic for other conditions in the first 12 weeks. That is the case. And so disabled babies will be targeted in the first 12 weeks. These tests have already been made for muscular dystrophy, for cystic fibrosis, for thalassemia, for that kind of thing, and they're getting more and more sophisticated. We must realise that if the 8th Amendment goes, if legislation comes in, it will last for about 10 years. And please don't be so naive as to think medical testing is going to go backwards, because it's not. This is $1 billion business, and it's only getting more and more refined all the time. So if you are not comfortable with abortion on demand, if you think that there are some serious cases where you need to have abortion for very specific, very hard cases, then ask the government to give you a proposal that does just that. Because this is like the person who needs medicinal cannabis for epileptic fits. We've seen a horrible case like that in Ireland recently.
Okay,
where it should be.
I'll have to ask you to. Of a moment just to catch our breath. What we're going to have now is we're going to have Fiona will spend 5 minutes rebutting Caroline, and then she'll spend about 5 minutes asking questions to Caroline, and then Caroline will spend 5 minutes rebutting Fiona and 5 minutes questions, and then we'll go to the floor.
Caroline is quite right that the definition of termination of pregnancy in the proposed bill is different to the definition in the Protection of Life During Pregnancy Act of 2013. The reason is that the Protection of Life During Pregnancy Act in 2013 does not have any term limits because it only allows for the termination of pregnancy in cases where there's a real and substantial risk to the life of a pregnant woman. And the reason why it's defined as allowing for either bringing fetal life to an end or early delivery is because it's only dealing with that one very particular in extremis situation. Whereas the proposed new law does define termination of pregnancy as bringing fetal life to an end. That's not the exact term, but that is, I think, close enough to it that we would agree bringing fetal life or unborn life to an end. I have the interpretation here, but we don't. It's going to be a bit boring for people if we just read out law at each other. A medical procedure which is intended to end the life of the fetus is the exact term, is because this only regulates, this bill is only about what you can do within the term limits. So it's only about what you can do on request with the regulation up to 12 weeks in situations of serious risk to health or risk to life between 12 weeks and viability. After viability, it will be a crime to terminate a pregnancy. And on that, I want to just deal with the, Caroline said the bill is splitting pregnancy into 3 parts. I mean, that is one way of looking at it, because it is 12 weeks, then 12 weeks to viability. But what might happen after the time that we usually consider viability, which would be about 23 or 24 weeks, is situations where there's a fatal diagnosis for the fetus and the pregnancy might be brought to an end. Because of the way viability is defined in the proposed law, which is the point in pregnancy at which, in the reasonable opinion of a medical practitioner, the fetus is capable of sustained survival outside the uterus. A fetus that has received a fatal diagnosis, that is a diagnosis of a condition likely to lead to death before birth or shortly thereafter, within the legal definitions, never reaches viability. That it's just about, it's terminological, it's about definitions. Might a pregnancy in a situation of fatal diagnosis be ended later than 23 or 24 weeks? Yes. Yes. But then, as is the case, for example, in most jurisdictions now, what a practitioner would do is to discuss with the parents how they want that pregnancy to end. Some parents will choose to continue with the pregnancy. Some parents will choose to induce an early live birth because they want some time with the baby. And some parents will decide that the best thing is to use usually a potassium injection to bring fetal life to an end and then induce what will be a stillbirth. And actually, you know what? There's no right answer to that. There's no one single right answer to that. There's just the answer that's right for that family. And all this law would do would be to create a legal situation in which a family can make that decision. That's all. I think we can probably all agree that the decision you make in a situation like that is the decision that is born out of love for your child and what you think is right for them and for your family. That's all. We might all think a decision is right or wrong, but you know what? We're not the ones making it. I think that's a very particular thing. I think the word abortion, which we all use in relation to that, it's not quite, I think, what we would usually think abortion would mean in early pregnancy, for example. It feels different, it's a different kind of situation often. But I just wanted to clarify that. In terms of the constitutional protection, I'm aware of Jerry's opinion. Caroline will be aware that I responded to it. Also, She'll also be aware that there is no constitutional court in the world that has ever held that there is a constitutional right to unlimited, unrestricted abortion up to birth. It doesn't exist as a constitutional right anywhere. And there is nothing to suggest it would exist as a constitutional right here, not least because the Supreme Court has said it is within the power of the state to regulate termination of pregnancies for the protection of fetal life, which is a common good. We might then disagree about where proportionality lies, what that zone of proportionality is, but there's nothing to indicate that any such right to unlimited abortion would be developed. Is it impossible? No. I told you I wouldn't lie to you. Is it impossible? No. Is it probable? No. It's just not. By reference to ordinary constitutional law. I don't really have many questions for Caroline. I'm conscious that I would like people to have time. So I will only pose two. Three quick ones. The first is a clarificatory question just to check. You said that there were, if I remember correctly, that there were 3 situations within the proposed law where late-term abortion would be permissible. And I'm just wondering, could you tell me how you define late-term abortion? Is it after 12 weeks? Because clearly, through the proposed law, if there's a risk to life or a serious risk to health, abortion would be permissible only until viability under heads 4 and, if I can remember, yes, under head 4. So I'm just wondering about the 3 situations and how you define so-called late-term abortion. The second question is to clarify again whether I'm right in my understanding that in a way we start from different, well, we clearly start from different places, but that we have different aspirations in a way that for you, successful governance of pregnancy results in a woman being alive, and that if the woman is healthy, of course that's preferable, but that the state's duty is to preserve her life, that that's a constitutionally successful pregnancy. Whereas, as I said, I think we should be aspiring also to the preservation of health and to the woman being the person who would decide in consultation with her doctors how much risk she was willing to bear to her health once it reached a serious level within pregnancy. I think where you stand on that question actually determines a lot about what you think about the proposed law, right? So what do you think we should be aspiring to achieve? And my third question, and I noticed you said this on the Late Late Show as well. You had the last word there, and so I'm glad that you said it tonight, because I was really curious about this. You said on the Late Late, and you said tonight that if you think that we should only regulate, I'm paraphrasing, but only allow for abortion in hard cases, for example, that we should ask the government to give us a different proposition. I think is that a fair representation? Yeah. So does that mean that So does that mean that if the government were to propose repeal of the 8th Amendment and its replacement with a provision that allowed abortion in cases beyond a real and substantial risk to life, that you would support that? So those are my 3 questions.
Okay. Yes, the voice again. Yeah. It is the case, of course, that no constitutional court in the world has ever had to deal with this kind of question, and no constitutional court has ever had to consider that they give no protection to the unborn life. It's also the case that we are, as they say, in uncharted territory. I hate the cliche, but it's so true here. No constitutional court in the world has ever had to deal with the fallout of a situation where a sovereign people have decided in a referendum to remove the most fundamental of all rights from one category of human lives in their communities. That is something that is a very serious and deliberate step, and many lawyers see it as going in one direction, and many others may cast it in one light, but in other writings they make very clear what they are looking for. And I do think that it's not fair to kind of characterise it as just looking for healthcare, when Fiona and I have debated this over very many years, and she's a really straight up, honest person to debate with, which I've really always admired, and a very fine academic. But we do have a different view, because Fiona, I think, will agree that she would like to see abortion available for whatever reason a woman would choose, at whatever stage of pregnancy she feels that she would need to have it. Would that be correct? Well, you think what restrictions would you... one of my questions to you then would be, in what circumstances would you propose that a woman not be allowed to have abortion? So, in this case, there were 3 questions that I was asked, and that's really the only question I'd like to ask Fiona, because as I've said, her group has made it very clear that they don't want substitution of any procedure to prolong a pregnancy in the fetal interest. Once a woman is entitled to an abortion, they want an abortion, and they don't want that to result in a live birth if that's not what a woman chooses. It's as simple and as clear as that, and that's what they have written. So, the 3 heads, is it after 12 weeks? My answer to you in relation to that is yes.
What would you define as later abortion?
Well, no, you were just talking about 3 heads, and what I want to say about the 3 heads is this, Fiona. You've talked about viability as being the cut-off, and the politicians have said that too, that in these cases that abortion is only allowed up to viability. Isn't that correct? Viability is only mentioned, Fiona, in head 4. I don't see it or any time limit in head 5, and I don't see it or any time limit in head 6. Will that be correct as well?
Yeah, do you want to tell people what head 5 is?
I will, of course, yeah. Head 5 is the risk to life or health in an emergency. Head 6 is the condition likely to lead to death of the fetus. Now, can I speak first of all about risk to life or health in an emergency? You all are aware, and I am the living proof of the fact, that where there is a risk to a woman's life, she will be delivered, and that's the end of it. And it doesn't matter what stage of pregnancy she is at. If it is necessary to deliver her, she will be delivered. What is being proposed now is something quite different. The wording is so clear as to be incapable of any other meaning, where the medical procedure allowed is one intended to end the life of the fetus. That's not the end of pregnancy. We already are allowed to do that. This is intended to end the life of the fetus. That has not been proposed as a treatment for anything to date. I was surprised to hear on the Late Late Show on Friday, Dr. Woodland did seem to make the suggestion that where a woman had diabetes in pregnancy and was suffering from an eye condition which could result in blindness, that abortion might be something that could have recourse to. This is new. Dr. Woodland is not, I'm afraid, an ophthalmologist. He's not an eye specialist. And that programme elicited immediate response from a consultant ophthalmic surgeon who said, is he seriously suggesting this is healthcare for a woman with diabetic retinopathy? It isn't. It's not best practice, it's not best care, and we don't do it. End of story. The other case that appeared in the Irish Times on Friday was a case of a woman with terrible underlying health conditions, with 1 lung and heart conditions and very, very complicated medical situation. And if you were to read Kitty Holland's article and see the press conference that was given in relation to this case by Colm O'Gorman, you would think, my goodness, this is a dreadful case, this woman was not looked after properly. If, on the other hand, you were to look at her personal blog, you will see her delight at her pregnancy, her absolute delight at the care she got from her cardiologist in the Mater, her doctors in Vincent's and in the National Maternity Hospital, and you saw a very different picture altogether. So we have yet to be shown a case where abortion is necessary to treat a serious health condition in a woman. And let's not forget, what is a serious health condition? A serious health condition, according to Dr. Boylan in an interview in The Independent, is whatever the woman decides herself is serious. This would force a massive change in obstetric practice, which the obstetricians themselves, but most importantly the specialists in these complicated areas, have not indicated as necessary to properly treat women, and we all want proper treatment for women. In relation to the condition likely to lead to the death of the fetus, I did publish a paper on that back in 2015, after Peter Borden had said in a primetime show with me, oh, Caroline, of course these babies aren't going to live, etc., etc. And when I did the research, I found that, number one, there is no agreement in medical or scientific circles that there is a condition called a fatal fetal abnormality, nor is there a list of conditions that satisfy that description. In every one of the cases, every single one of the cases that are described in that way, there has been fetal survival. And so what you're deciding to do in these cases is to cause death, to hasten death. And that is a choice that voters must make. There is no question of women having to carry dead babies and not being able to do anything to deliver them. That is a myth that has gone abroad that I must tell you is entirely untrue. So that's all really I have to say on these points. Thank you.
A woman not be allowed to have a termination. Well, my view is that there is a point in time in pregnancy when fetal development becomes compelling, and we should step in to strictly limit access to abortion, certainly in situations where a woman's life is at risk. I would say abortion should be permissible if that's what she decides. It would be right in conjunction with her doctor. I think that in situations of, if I use the shorthand fatal diagnosis, it's defined in the proposal as a condition likely to lead, highly likely or something, to lead to death before or shortly after birth. I think in those situations people should be able to access abortion. And I think then as pregnancy develops, the severity of the risk should need to be higher, risk to health, before you could, so that as pregnancy develops you would need a more severe risk. Caroline referred a few times to my group. I don't really know what you're referring to. It may be a blog that I'm part of the editorial team of, and that
proposed law isn't restrictive at all, because we know that I think it's 90%, I think Fiona can give an exact figure, of abortions in the UK do take place in the first 12 weeks. So to allow abortion on demand in that period isn't restrictive at all, in fact.
Great. Okay, now we're going to open it up to the floor. So microphones. Whoever has the microphones, perhaps they could stand out along the sides. Okay, I see one coming up here. So. And if you could introduce yourself just as you ask if you're involved with any campaign group, and also I'd ask you to be respectful to everyone, speakers included.
Hello, thank you. My name is Jennifer, and I'm involved with Parents Together for Yes. I'd just like to ask Caroline, do you agree that a no vote will not stop abortions happening in Ireland?
I do. And I note the fact that where abortions are available on a more liberal basis in one country and more restrictive in another, there's always been abortion tourism. You see tourism into Holland from France, etc., etc. I agree with you. I don't like it. I think we all need to work together, and I hope after the 25th, and I really do mean this, that we all will work together to try and get better solutions than abortion for women with unplanned pregnancies.
Hi, I'm Tanya Keane and I'm with Waterford Together for Yes. I just want to ask yourself, Caroline, you've mentioned a lot of the cases there for certain women where this point is directed to you. You've mentioned Savita, you mentioned Michelle Hart, and you mentioned Miss P. You forgot to mention other cases, in particular Miss C, who was a 14-year-old girl and who was raped by an uncle. You say that the 8th Amendment does not affect women, but in fact she was prevented from travelling to England with her family by the guards from a high court, and she was prevented from having that termination. She was 14 and she was made remain in Ireland as she was dragged through the courts like so many women who've been raped in this country. And are you saying that the 8th Amendment did not affect her?
Miss C, in fact, had her abortion and has gone on the record since as saying that she's been suicidal as a result of it. She regrets it. She gave an interview in the independent newspaper. Miss C did. Miss C, that's what you asked me about, and that's the answer to your question.
Hello, my name is Kieran O'Connor. I'm a medical doctor in the city here, and I just had some observations and questions really about the health versus life issue. Anyone that was watching the RTE programme on prime time last night saw Dr. Eamon McGuinness and Dr. John Monaghan clearly stating that all treatment in their careers, all treatment that is necessary is given to safeguard the life and health of the mother, and they cited various reasons for that. We have the Protection of Life in Pregnancy Act, which safeguards the life of the mother, including the threat of suicide. But from my own point of view as a medical doctor, actually the guidelines of the Medical Council are what would influence me most substantially, and that is that abortion is permissible where there's a real and substantial threat to the life of the mother, and this does not have to be imminent and it does not have to be inevitable. As regards the health outcomes, we actually do have population level evidence in this country about maternal health outcomes. Our maternal mortality statistics are statistically significantly lower than in the UK, where they have unlimited abortion, and the morbidity outcomes, in other words the health outcomes, are equivalent to the UK. When we have this references to maternal health and that these are grounds for abortion, what we're really talking about is maternal mental health and the ground C in the UK. And I just refer you, just before I came out here, I looked at the British Pregnancy Advisory Service website. It's the main abortion procurer in the UK. This is their own data, it's not pro-life data. This is a statement from BPAS, and it's saying that the abortion law in the UK proposes a problem for women and doctors. It's not the case that women necessarily are at risk for damaging their mental health if they continue their pregnancy. The law requires women and doctors to indicate that this is the case. National statistics in the UK cannot reflect the true reasons for abortion, only the grounds cited under the law to make them lawful.
Do you have a question for either of the speakers?
My question really is, my question for either speaker actually is that, isn't it really the case that this is, the healthcare ground is really ground for abortion unlimited under all circumstances, and has nothing really to do with healthcare, and it's just not truthful to say that it is healthcare.
My answer to that actually is going to sound a bit lawyery, but bear with me for 3 minutes. There is no comparison between the ways in which the health grounds are expressed as a matter of law in the UK and the ways in which the health grounds are expressed as a matter of law in the proposed new law. So under Section 1 of the Abortion Act of 1967, all you have to do is to establish that there is a greater risk to the health of either the pregnant woman or her existing children of continuing with a pregnancy than there is of ending a pregnancy. And as was accepted in the parliamentary debates in both the Lords and the Commons in 1967, that puts in place a legal standard that will statistically practically always be met. That is the legal standard in the UK. And by the way, that permits of lawful abortion up to 24 weeks. In contrast, the Irish law, which is proposed, would say that after 12 weeks and up until viability only, the health ground is where there is a serious risk to the health of the pregnant woman. On any reading, legal, medical, or sensible, that is a substantially higher legal standard than the standard in the Abortion Act of 1967. And so I have to say, I don't find the arguments by analogy with Ground C convincing, because it doesn't bear any resemblance to what is actually proposed in the Irish law. And I would recommend that people actually just read Section 1 of the Abortion Act of 1967. You Google it and it'll come up. It's very clear what the standard is. It's very clear what the time limits are. It's very clear what the process is. It's very clear if you then read Head 4 of the general scheme proposed here, that the standard is higher, time limit is different, and the process is substantially more rigorous.
Chance to say something. I know the 3 front rows are all Repeal with their questions ready, but just bear with me 1 minute. It does say that there's a risk, immediate risk to life or of serious harm to the health of the pregnant woman in circumstances where doctors in this country are obliged by their code of ethics to practice evidence-based medicine, and no evidence has been produced that it is ever necessary to directly end the life, to kill the life of the baby in the womb in order to address a health complication in a woman. Certainly it is necessary at times to deliver the baby, and certainly that is and should be done, but it has not been demonstrated that you need to end the life of the unborn baby in order to address either health risks or risks to the life of the woman.
But that answer concedes that the legal standard in the proposed law is substantially different.
Not where Dr. Boylan has said that serious means whatever a woman says is serious herself, Fiona, I'm afraid.
Well, I mean, 2 doctors, sorry now, 2 doctors. Briefly with the certification thing, because it has come up, right? So in the UK, 2 doctors have to certify to this relatively, basically the attendant ordinary risks of pregnancy are almost always sufficient to meet the legal standard in the UK. But here, because it's a higher level of risk, there has to be 2 doctors. One of them has to be an obstetrician, and the other one, at the moment it says should be an appropriate medical practitioner. I would expect to see that tightened actually by the time we get to, if we get to an eventual law, to look something more like
it should be, because we've both probably seen the Twitter discussion in relation to it, where there's a new definition in the 2017 amendment which suggests that somebody with a basic medical qualification.
No, hold on.
And that could be your
sorry.
driver. I'm agreeing with you, Fiona. I'm agreeing with you. I'm agreeing with you.
Medical education is defined by the Medical Practitioners Act of 2007 as a medical degree and registration.
It's amended. It's amended in 2017.
I know.
I didn't know that either. It's
but
not.
in any
I can
case,
give it to you.
we could expect expect that the appropriate medical practitioner, I would not be surprised if that were tightened to look rather more like it is in the Protection of Life During Pregnancy Act, which requires a specialism connection, doesn't it, to the basis of the risk. So I mean, we're talking about doctors here, and one of them has to be an obstetrician. We're talking about a substantially different legal standard, and so I do think...
Actually, let me just quote, may I, from the 2017 Act? Medical practitioner means a person who holds a basic medical qualification, but I agree, it will very likely be tightened, of course it will.
So basic medical qualification is defined by the medical practitioner. And it doesn't matter. We're getting too lawyery.
I agree.
We have, if I can just say, we have a question here from the lady in white, then we have a question from the lady over here. There was a gentleman over there, and then I'll come back and we'll take the next. We'll go back to
yeah, I'm Jackie Corcoran. I'm from Waterford. I'm a media consultant, and one of my clients is the Green Party. And I have a statement as well as the gentleman behind me. This is from Senator Grace O'Sullivan, and it's in response to Father Liam's article in yesterday's News and Star. Father Liam, as I'm sure everybody here knows, is one of the main organisers of this event. And the statement is: I was impressed when contacted by Father Liam some weeks ago when he called me for advice around setting up this public debate. I'm baffled and hurt that he would have taken the stance he did when he engaged in a personal attack on me in his piece in yesterday's paper. I have to address his comments...
Okay, can I just stop you there, because that actually has no relevance to the actual debate.
Seriously, excuse me one second. I don't know anything at all about these articles.
I don't know about the articles,
and we are only here to talk about them. I honestly haven't seen the articles. I have no idea.
It's not fair. People haven't seen the article. People haven't seen the article.
I have not read these articles. We're here to discuss the referendum, not ad hominem attacks. I'm sorry.
Sorry. Hold on a second.
Judge, let's read it and judge.
No, because if you have a question, that's fine. But as far as I'm concerned, I'm the chair here, and I heard. Right.
Okay. Based on this, the question is around morality and compassion, which the article was focused on. The article focused on morality and compassion and questioned the morality of Senator O'Sullivan and women in Ireland who are of the opinion that a vote for repeal is a personal choice. It's a matter of personal choice. I would like, and that unless we...
Don't summarise the article, just ask your question, please.
Unless we repeal the 8th, we cannot deal with the reality of what's happening in Ireland today, of women taking abortion pills at home with no medical supervision, and women travelling to the UK. Abortions are a reality in Ireland today. How do the two debaters here propose that we deal with the reality of abortion today as either with or without repeal? On both sides, please.
I'll take it first if you like. Well, first of all, I'd have to say we are talking about what we're going to be voting on the 25th of May. And what you're talking about is what will happen in either event. Isn't that really the case? What will we be doing for women? We know that in the UK, where it is legal to buy abortion or to get abortion pills from a doctor, that there are a huge number of women also getting abortion pills from the internet and taking them without medical supervision in their own homes and whatever, and that this has been described by the head of the British Pregnancy Advisory Service as a staggering problem. It's a problem all over Europe, not just here. It doesn't matter if abortion is legalised, it is still going to be a problem. So, yes, they are. Well, hang on one second. Okay, wait now. Let me deal with that too. It isn't criminal, you're right.
It is a criminal offence.
To take the pill.
To have an abortion outside the body.
Oh yeah, that's absolutely right. Yes, it may surprise some of you to know that abortion is actually a criminal offence in the UK. and that the 1967 Act gave you exceptions to that criminal offence. They gave you circumstances in which it would not be a criminal exception in that 1967 Act. But if anybody has an abortion, does an abortion outside the terms permitted in the 1967 Act, it is a criminal offence, and there can be a sentence which was penal servitude, which I think now is life, isn't that right, Fiona? Yeah, life sentence is possible. And in the UK, there have in the last number of years been a couple of prosecutions. There was a notable one, I think, in the last 4 or 5 years, Sarah Cat, a woman who, like you were describing, who imported abortion pills from Mumbai in India and took them when she was 39 weeks pregnant to do the abortion of her full-term baby. And she was sentenced to 8 years in prison, and on appeal that was reduced to 5 years. Exceptional cases like that do occur, and I know that there is an international campaign to decriminalise abortion, and particularly to decriminalise it against women. That is a discussion for another day after we have made the first decision, is what we're going to do about the protection in the Constitution. But just to say to you, Anne Farady, again, the head of BPAS in England, has said, if you decriminalise abortion, then all the restrictions and all the conditions you have to fulfil in the Abortion Act to have a permitted abortion, they all fall away because there's no sanction. There's no punishment. And if we were to completely decriminalise abortion like that, I think it puts us in line with 3 countries in the world: Vietnam, China, Canada, and parts of Australia. So most countries actually do have sanctions for abortions outside the permitted categories, and they have them there because they think that they are a deterrent. But we do not want to see women criminalised, and we have not seen any prosecutions of women in this country since the 8th Amendment.
What I want to say, the first thing briefly on criminalisation is that under the 8th Amendment it is the view of the Attorney General, and we saw this when Reid Smith's amendment bill was proposed, that the state's duty to defend and vindicate the right to life of the unborn does require the state to criminalise abortion. So the Attorney General's view is that criminalisation is required by the state's duty under the 8th Amendment. If it is repealed, the proposal in the new law is that abortion would remain a crime outside of the permitted limitations or exceptions within the Act, but that it would never be a crime for the woman who had an abortion. So it would be a practitioner. And that is, I think, both designed to dissuade and designed to protect.
And so the decision, that decision, I agree with what you said exactly, that decision will be a decision for after the referendum, when you will have to talk to your TDs if the referendum goes through, which I hope it will not, and you will have to consider, is there value in having a criminal sanction there? Right. For extreme cases like the case of Sarah Cat, as I've said, who procured her own abortion at 39 weeks pregnancy.
I want to deal with the morality. May I deal with the morality point? Yeah, the morality point, because I actually do think this is important. Do you know what? In my view, there are good moral arguments that are very meaningful to many people against abortion in all circumstances. They're arguments that I absolutely respect. There are also good moral arguments that are very meaningful to many people in favour of the legalisation of abortion at different levels of liberalisation, depending on where. So I've already expressed my ethical position on this. I think different people have different ones. And I think that when there is a matter of profound moral disagreement, which I think we might agree is the case here, it's very difficult to find an answer that feels like the right answer. I think we can all agree on that. But I do think that repeal, I do think there's a moral case for repeal. I think the moral case for repeal is about love, and I think it is about care. It is about how we show our love for each other and how we respect our ability to show our love for our family. Not everybody will agree that that is true, but you know, I have a sister. I have 2 sisters, they're great. Well, one of them is a bit nicer than the other, but I have 2 sisters. And one of them is 30, she has a fantastic baby, he's 15 months old, he's the light of our lives. And she nearly had a stroke when she was giving birth to him. It's not terribly unusual. It sometimes happens. And her consultant told her, she doesn't mind me saying this, her consultant told her that if she were to become pregnant again, there was a very high likelihood that the same thing might happen. And she couldn't tell my sister, you know, what would be the outcome. And, you know, in my view, in that case, she's a baby at home. She's a husband. She loves them. They need her. I think if she becomes pregnant again, the loving thing is to let her decide whether she's going to risk leaving her baby without a mom, or leaving her baby with a mom who's really ill. And all I think that law really should do here, and this is a big part of my sort of ethical position on this, is I think law should support us to make decisions about this.
We have a question here, and then we have a gentleman who's waiting down there. Both have been waiting.
Hello, I want to welcome the two speakers here. They're very welcome. It was very interesting to hear the two views. My name is Alice Hughes. I'm in pro-life all my life. Now, what really puzzles me more than anything, how a woman is allowed to murder her own child. Now, I know that sounds very, very hard, but I can't understand it. Now, I know all about abortions, reading about all the different views, and my heart goes out to the women that have to have them. Now, I've read all about their health. Now, we had a convention of doctors in Dublin about 10 days ago now, I'd say, and they said that no woman needs an abortion for her health. That their doctor, if he's capable enough, and he should be, if he's into the subject of abortions, will be able to cope with her health, even with cancer.
Okay. I would like to answer that. My answer is very...
I'm sorry, I'm not quite finished.
I thought you were finished.
Now, I have nothing against anybody. I love everybody. I love the people that have to have the abortions, because that's their way and that's what they want. But I find it very hard to understand it.
Okay, that's fair enough. So if Fiona can just answer your question, that would be great, because we don't have that much time.
Yeah, so my answer to you is very simple. If you believe that, which I believe you do, then you should vote no. That's my answer.
If that's okay, we're going to move on. Yeah.
My name is Fintan Parr, I'm a former journalist. And
this is a poem written by...
Okay, I'll have to ask you, unfortunately, I'd like to hear it, but maybe afterwards. We have to move on now to the next question. Sorry,
I'll reintroduce myself. My name is Fintan Parr. Right? I'm a former journalist and a long-time pro-life campaigner. I find it fascinating to hear that Dr. Boylan has contradicted himself many times over the past few years. Something wrong with this mic. Anyway, the question I'd like to ask is this. On Saturday, he admitted that life begins at conception. So I'd like to ask Professor de Londras two questions. One is, when does she consider that life begins? And second of all, does she think that do you think that people should have a right to kill an unborn child?
So I'm going to answer both of those questions together. I believe that biological life begins at conception, but I do not believe that human personhood begins at conception. I don't think and as a result of that, I believe that we should make law that enables people who share that view and for whom that is right to decide within clear limitations whether they will continue with their pregnancy or end it.
Okay, we'll go to this lady in the red top, and then there's a lady in a beige polo further down. If we could get the microphone to her. Thank you. No.
Sorry.
You hear me now?
Yes.
Sorry, I'm not as eloquent as most of the people here, and I don't usually talk at these things, but it just struck me that with all the modern technology we have, like even with modern technology in America, there's no evidence to say that babies start to feel pain at 8 weeks. And we know, what science tells us, that by 8 weeks, all the organs of the baby have been developed. They have their limbs, they respond to light, they respond to touch, and now we have knowledge that they also feel pain because their nervous system has developed to that level. And I'd like to know, my question is, why has Leo Varadkar, who's a doctor, decided 12 weeks is a good time? Why not earlier than that? I'm sorry, it's a simple question. I don't understand it. Sorry.
Okay, we'll do it. 12 weeks first, I think, and then I'll just deal with the other aspect of what you have to say.
Okay. So I'm not going to speak for the Taoiseach, who I don't believe I've ever met, but just on 12 weeks as a basic idea. So if we accept, which maybe you don't, that some protected period is necessary and appropriate to deal with some situations, and of course we have to pick a time, right? So there has to be some time. 12 weeks is the time that is most commonly used in countries across Europe that have a similar legal regime, so it's a kind of a standard time, in a way, or an average time. 12 weeks LMP as well, as you know, so that's 12 weeks from the first day of your last period, which is how you count pregnancy. It's not 12 weeks from conception, but that may not be a meaningful difference to somebody depending on your view. And I think 12 weeks, the idea of 12 weeks, as far as I understand it, is to say that there would be enough time for somebody to have detected their pregnancy, and also that there would be enough time for somebody to have been able to reflect on what is the right decision for them. I don't think any of us would want a situation where the time limit is so short that somebody would be sort of feel rushed by the law into making a decision. And when you consider that some women, well, a good few women actually use contraception, as I'm sure you know, that actually stops your periods. So you wouldn't necessarily always detect pregnancy because you don't miss a period, you don't have periods, because your contraception stops it. You mightn't necessarily detect a missed period, and you might be 8 or 9 weeks or 7 or 8 weeks before you knew you were pregnant. I think it's an attempt to create a balanced time, a time that gives enough space for reflection, so that the law isn't bouncing people into decisions inadvertently. That would be a perverse outcome that we wouldn't want.
First of all, in relation to the 12 weeks, I know the point has been made by a lot of GPs around the country that without ultrasound machines, they're not going to be sure that a woman is 12 weeks pregnant if she says that she is, but that's just a point. In relation to pain, as I see a lot of the Repeal people in the front here wincing at what you have to say, I'll just tell you what my understanding is in relation to fetal pain. Looking at the Royal College of Obstetricians and Gynecologists, guidelines in relation to fetal awareness, I did note Rona Mahoney, the Master of Hollistrate, suggesting recently, I'm sorry, but we'll hear the poem afterwards. Rona Mahoney, the Master of National Maternity Hospital, did say recently that she thought the fetus felt pain at around 26 to 27 weeks. This was at a debate in UCD. That would be 1997 data from the RCOG. In fact, their most recent report indicates that they think the fetus has got enough of nervous development that all the connections have been made necessary in the brain by 24 weeks that you could say that pain is felt. But they said that they couldn't deny that there might be a more raw form of pain experienced earlier than that, about which they couldn't be sure. But they certainly said pain relief should be given, and that is one of the reasons why you have the fetal injection after 22 weeks pregnancy. The only other thing I would add to that is more recent research done in Israel has suggested, particularly when you're dealing with fetal surgery, which is done now increasingly, that you should give analgesia, that's pain relief, to babies from 18 to 20 weeks pregnancy when you're doing fetal surgery, and they've suggested that that also should be the case when you're talking about terminations. So that's the latest research as far as I know on it.
Very briefly on the scans, it will be very briefly on the scans. The doctors up to the 12 weeks will be legally obliged to certify that they're satisfied that you're within the protected period. So we can expect that, if you get close to the end of the 12 weeks, people would have to go for scans, which realistically is going to reduce the time as well. And the point on pain and so on, which I'm sorry I didn't address, to be honest, my view is that if somebody believes, as I responded to Fintan, if somebody believes that human personhood begins at conception, then 1 week, 12 weeks, 24 weeks, 30 weeks doesn't make a difference, does it? I mean, that's your position. I completely respect that. That's absolutely fine. So, I mean, there wouldn't be, if somebody... Yes, no, I understand that that's your perspective, and from that perspective, I should imagine that no time would be acceptable.
And can I just repeat, for some reason we've spent an awful lot of time tonight talking about the content of a bill about which there are absolutely no guarantees and which you have no vote in relation to. It's irrelevant. It's irrelevant.
We had originally intended to end at around about 9:30. Now, can I ask people if they would like it to go on a little bit longer? Fine, we'll say to 10 o'clock and then we cut off. The other thing is, I'll have to say to that lady, if she keeps interjecting there, I'll have to ask her to leave. Sorry, she's not listening to me. Okay, I had a woman in beige who was down the back, a woman in beige. A woman in beige down here, and then we had a gentleman up here, and then we had two gentlemen here, and then we come back to others. So the lady in beige, if you could stand up and say who you are.
Hello, Teresa Gorman. Oh God, sorry, Teresa Gorman. I've recently joined the pro-life canvas because this issue is something that I feel very strongly about. My question is directed at both speakers. You kind of touched on it a little bit actually in what you were talking about. During her speech, Caroline mentioned, well, she asked a question, what happens to the fetus who is alive after an abortion? And she mentioned some numbers from Canada and the UK. I'd like to mention one live-born baby who was born in 2015 in Queensland, one of 27 babies live-born after a late abortion at 5 months. The baby survived for 10 hours without medical intervention. These babies are put in corners of hospitals. Okay, now my question is about compassion, and the Americans like to think they're being compassionate about abortion. They've had it for nearly 45 years, so they want to be figuring it out by now. In America currently, since George Bush was elected, they brought in a law that if a baby is live born after an abortion, they must receive medical attention. It is actually illegal to just let that baby die. Okay? Unfortunately, it doesn't always happen. It is well known that up to 3 to 4 babies in America per day are finished off by the abortionist once they are removed from their mother's body. Okay? Now, we cannot talk about compassion in this whole debate and erase the baby from the picture. So my question is, in relation to the word compassion and care, we are perceived as being dinosaurs in the pro-life movement. I am very pro-woman. I have a 16-month-old baby. I also had a miscarriage in September. I know what I'm talking about. I would like to say to Caroline, as we are perceived as dinosaurs, how do we pro-life people show that we are compassionate towards women? And to Professor de Londras, how do you propose to show compassion for babies?
Those are really fair questions, and and the poor lady over here is still trying to tell us her poem. We'll have to wait till afterwards with that pleasure. We will listen. Sorry, well I think people...
We actually are having problems hearing our speakers because this lady keeps shouting. I'll have to ask you, if you do it again, I'll have to ask you to leave. Now I'm sorry, but we must hear our speakers.
We will hear the poem afterwards, if that's okay. Yeah, okay? Anyway, just, now I've got to think about what you're talking about, sorry. Pro-lifers and compassion for women and care for women. The truth of this is, and this is the truth, I don't know anybody, and I have been involved in the pro-life movement on and off. I don't work for any organisation, but I volunteered in it since 1992. I don't know anybody who hasn't also been involved in some manner in looking after women with unplanned pregnancies or looking after women in very inopportune circumstances with small babies and young children. I don't know anybody. I mean, this is the truth. And I won't speak for everybody else. I don't see why people have to defend themselves all the time, but I can tell you I was at a meeting this morning on a group that I've been involved with for 20 years, and we work hard through the year to raise money, and we meet social workers, and we look after the best we can a certain group of women. We all do a little bit that we can. I look at people like the lady who started Hugh's House after her son died, who managed to get a lot of companies to sponsor rooms. She has got a house sorted in Dublin, and if you've got a baby with one of these terribly serious conditions that isn't likely to live very long, the families can move into this house, volunteers come in, they clean it, they make the dinner, they make you comfortable, and about 6 families at the moment are staying in one house, and there's a second one on the go in Dublin. People really are trying to do something to help. We are not the cruel dinosaurs that you'd like to think that we are. We really aren't. We all are. I agree with you. I agree with you. Everybody wants the best. We do all want the best for people. And we do want people to be able to have their babies. And I said in UCD recently, sorry, this is the laryngitis speaking, I think. I said in UCG 2 or 3 weeks ago when I was speaking there, And there was a lot of young women in the audience, and a lot of them, like some of you, had Repeal t-shirts on as well. And two of them came up and hugged me at the end of it, because we all are speaking to each other on the same page, if we really were honest with each other. There are a lot worse things than pregnancy that can happen to a young woman. We have to address the most common reasons for women not wanting to be pregnant. And the most common reasons, according to Goodmack or according to the Trinity study, are lack of supports, lack of financial ability, lack of ability to continue education. These kind of things we seriously have got to address, because we all know most pregnancies, the lion's share of them, are of healthy babies in healthy mothers who shouldn't have to choose abortion as the only choice they think they have, because they think there are no other options. Yes, I see all the Repeal hands going up now. You're well coordinated, you're all texting each other, but give everybody else a chance to. I see them all.
Okay, now, can you give Fiona a chance? Okay, but look, I've got to chair this, and I have a number of people who want to ask questions.
So I would say that people I know who would advocate for repeal probably share the characteristics that Caroline is talking about as well. You know, it is true that we all more or less want the same outcome. We disagree on how we get it. I think it is sometimes a non sequitur to talk about supports, because people who advocate repeal of the 8th Amendment and the introduction of lawful and safe abortion also advocate the support of parenting and parents and children and better maternity care and better social welfare and better payment in early pregnancy and free childcare and good education and good domestic protection for women from domestic abuse. We all advocate all of those things. If we introduce lawful abortion, it does not mean that social problems disappear. If there's one thing we all know, it is that making abortion illegal doesn't stop it, and making abortion legal doesn't start it. What determines whether or not people have abortions is social conditions in many cases, the situation in which they are, their health care, their ability to deal with potential adverse health outcomes and so on. So actually what we should be doing, and I think, I'm not connected to the government, but my understanding is that this is what they're doing, is to think about a transformation of how we deal with pregnancy and parenting. You know, better consent classes, better support for parenting, better financial supports, better tax breaks, better childcare, better health care, better insurance.
Good evening, everyone.
No. And if you can say who you are.
Yes, it's on now.
Good evening, everyone. My name is Dr. Roland Cleary. I'm a GP registrar. So I just wanted to make one or two points. Firstly, Simon Harris hasn't consulted the ICGP or any GPs in this country with rolling out an abortion-led GP service. Okay, I take great exception to that. I didn't put myself through 5 years of medical school, toil and slog to become a part-time abortionist. No complication with GPs to date, yet we're expected to lead out Simon Harris's abortion service. We're expected to counsel patients pre-abortion, conduct an ultrasound as the gestational date. No, excuse me, I'm entitled to come into it. No, from a personal point of view. Okay, and we're expected to lead out this abortion service. But I suppose my question as a doctor, and I will be voting no, and I would encourage everyone else to do so. My question to Fiona in particular is, I'd just like to say, quote William Binchy, who's the professor of law. No, it's a human rights issue. It's a human rights issue. I just want to get to the nub of that. And he said, if human rights are to have any meaning, one human being should not be entitled to choose to end the life of another innocent and defenseless human being. That is the cornerstone of law. And I'd just like to ask Fiona, what do you think of that?
Sorry, Ron, I didn't at the very end. I heard what William said.
No, so I would just like to say, if human rights are the cornerstone of our law and our civilization, why would you condone, well they are, because without human rights none of us would be here, Okay? Why would you condone unrestricted abortion up until 12 weeks, which doesn't even deal with the complex cases that my friends over here are so concerned about and who I sympathise with?
I have the question now. First point, my face, by the way, was at the word civilization, which I find troubling generally. So first point, all doctors will have a right to conscientiously object to the provision of pardon me? It is in the Protection of Life During Pregnancy Act.
Can you just let her answer the question?
It's in the Protection of Life During Pregnancy Act. It's in the general scheme of the proposed law, and it is protected by the constitutional right to freedom of expression of religion. Get real here now, okay? Just on that point, which is the phrase that Professor Vinci likes to use sometimes. The second point about human rights. So there is, first of all, sometimes human rights are in tension with each other. Right? So, for example, my right to an appropriate level of healthcare may, if I'm your patient, come into tension with your right to your conscience. Right? We accept that. Law's job is to mediate those tensions in rights. William, who I actually highly regard, he was extremely good to me as a young academic, and I really have great regard for him. I like him very much, and I believe that he is a very good faith actor in this because he believes strongly in his position, and unlike some people, he's extremely consistent. He believes we should protect the rights of children after birth as well as before birth, and I really respect but his characterization of this I don't accept. I don't think that that making abortion, which is part of healthcare, safe and legal within a regulated system, somehow undermines our culture or our human rights, and we disagree on that, and that is why we would never vote in the same way. Sinead, that's it. No, there's no follow-up questions as far as I'm concerned.
Sorry, I have two men who've been waiting here a very long time, and then there's a young lady just here with the black jumper. So we just go 1, 2, 3.
Well, thanks to all. But I'm very grateful for the measured and respectful way that this debate has been carried on by the two speakers. I was a young man when I voted in 1983, and that certainly wasn't the case at that time. And I'm glad to say it seems as if we've grown up a little bit in this area. My question specifically, my name is Mark Cosgrove, and I'm actively canvassing for a no vote in Waterford City. And I have the joy of being able to go out each night and meet people of Waterford City from all sides of the argument. And one thing that really strikes me when I'm talking to them is the level of compassion and care that they have for mothers and children and babies, unborn babies. And what I get asked, particularly by the people in the undecideds, but this comes up from both the no's and the yes people as well, is that they tend to say, look, I'm really against abortion, but I have to consider those cases where people feel that they need to end the pregnancy because of what has become known as fetal abnormality. And I know that you've clarified, Caroline, that there is no such diagnosis. We like to call it a life-limiting condition. But is it not, we're not actually voting for abortion for life-limiting conditions. I understand from what I read that only about 1% of abortions that take place in England and Wales is on the basis of life-limiting conditions. So if we go and vote on the 25th of May to repeal the aim, are we not, for the case of one baby in that situation, taking the lives of 99 other healthy babies from healthy mothers? And does it not make more sense to vote no and push this question back to the politicians to get honest with the people and look after and legislate for those very difficult cases which the people of Ireland do care for?
Yeah.
That is what I would say. I'd say that that is correct. There is no doubt that if you remove and if you repeal completely the 8th Amendment, that you will have removed all protection in the Constitution for all babies, and you won't simply be talking about hard cases. You will have unlocked Pandora's box. You will leave the way open for what has been described, as I said, by a lawyer, an expert advising the repeal side of this debate. You will have enabled interim legislation as a stopgap on the way to light touch or almost no regulation at all. That's the truth.
Sorry, I'll answer as well. So the first thing is, if you believe that it would be right to allow for lawful abortion in those cases, then you would have to facilitate repeal of the 8th Amendment. It might not be this one, like you might say, and I recall I did ask Caroline earlier whether she would support a different amendment, and she didn't clarify what she would support or would not support, but there were a lot of questions going around, so that can sometimes happen, but I would be interested in that. But you would have to then have another referendum. So under Article 40.33, the settled constitutional understanding is that we can't legislate for these kinds of conditions. I have to say that I did argue in 2013 that that wasn't necessarily the case, that there is a phrase within 40.33 which is as far as practicable, and that within that, with a little more imagination, we could have said that the Constitution might have permitted legislation for cases of fatal diagnoses, but successive Attorneys General, who are, in the absence of a court, the authoritative interpreters, have said that's not the case, and certainly under the X case it's not the case. So I would have been, to do that without a referendum, right, you have to argue for constitutional innovation. You have to argue for courts interpreting this provision in a more expansive way, which I'm sure many of you will recall is precisely why many people who are, I assume, now advocating no, also advocated to have the suicide ground removed in 92 and 2002, because they considered that an illegitimate judicial innovation in terms of the 8th Amendment. So you're in a bind, right? You're in a bind because you can't do that under the current Constitution. You just can't. And so then you have to decide, in a way, in the utilitarian way that you put it, whether you think it is worth that good for what you consider to be a bad that would come with it. And that is a decision you make in the ballot box. That's the lesser of two evils. Well, and that's the way you want. That's the way you consider it. That is what voting is, right? We weigh up things. Fine.
Can I just say very, very briefly then on that? Yes, I know that an argument was made by Fiona and a couple of other academics that you could, without a referendum, legislate for abortion where the baby had a condition which meant it was unlikely to be born alive or to live for long after it was born. And I also wrote in relation to that too. And my understanding of it was, you probably all know that the Irish translation of the Constitution is the one that is heavier weighted, is the official and authoritative version. And in that it talked about Ceart na meo gan bre con amaha, which is the right of the living who haven't been born to their life. And it wasn't kind of sale. Sale, as you know, you Irish speakers out there, means a lifetime, the life in front of you. But baha is the life that you enjoy at this minute. So the Constitution, as it is currently written, doesn't discriminate between born people on the basis of ability or disability, and I argued doesn't discriminate against unborn either on the basis of ability or disability. So a referendum would be needed in relation to that. And to answer Fiona's question, no, I think anything that repeals the 8th Amendment, removes it in its entirety, is extremely risky and most certainly opens the door to legislation for abortion outside conditions and situations that most people would want. I think that's made very, very clear. And yeah. So that's why I'm advocating a no vote on the 25th of May.
Okay, we have a gentleman here, we have a young woman here, we have a lady in white down the back, then a lady in black and white here, and then this man, and then we'll probably have to finish. Very quickly, make your question.
Can I be heard?
Yeah, no statements please, just questions.
Thank you. I was about to mention that to you as the moderator. My name is Jerry Kelly. I'm a father of 5 and grandfather of 8. I am voting yes in this amendment. The reason I'm voting yes is manifold, and I won't go into it all here, but I am pro-life. I am not in favour of abortion for the sake of abortion, but this abysmal law that we stuck into the Constitution based on this amendment, the 8th Amendment into the Constitution, has muddied the waters legally, and I'm glad to see Caroline is representing the words of legal people.
Okay, do you have a question?
Yes, my question, I have a question in 3 parts. One's for Caroline. Caroline, the repeal of the 8th is not going to prevent 3,000 women going to Britain for abortions there. And if a woman who can't afford, and I stress the word afford because it's only women that can afford to go to England for abortion, take a pill to abort, they are, in legal terms, subject to a 14-year term in prison. Now, you as a lawyer, are you going to campaign for the imprisonment of any woman found to have taken an abortion pill?
Okay, that's great. I won't have time for the rest of your questions.
Just move along quickly and then answer. No. So may we have the next question, please?
Yeah, pass the mic, please, to the young lady in the black jumper. And then we're going down to the back white. Very quickly, and a question.
Hi, I'm Abigail Deegan. I'm 15 years old, and I suppose, well, I'm pro-choice. But the point I want to get across is abortion is never an easy option. I think that needs to be told enough. You can be pro-choice and support adoption, you can be pro-choice and be a mother, you can be pro-choice and be a doctor, you can be pro-choice and be a Catholic. You can be pro-choice and never get an adoption yourself. Sorry. You can be pro-choice and never get an abortion yourself and be completely against abortion. Being pro-choice is about supporting women's decisions, and I suppose my question is, in 2018, are we really still not trusting what women do with their own bodies?
I think we think that was a rhetorical question, very eloquently put, especially 15 in a room with
Okay, there's a lady down at the very back in white. And then there was a lady up here in black and white.
I'm a mother and I'm a nurse, and I'll be voting no. My question is, Fiona, you said, you talked about the core principle of democracy and a democratic society, that we have a vote, that we can put the politicians out if they don't do as we want. I think the core principle of any democracy is our voice. Why would we give away our voice on the 25th of May? Because if we repeal the 8th, we effectively give away our voice on this issue forever. The politicians will be the ones who will make the decision. We also know that Leo Radford, Simon Harris and Simon Coveney all changed colours on this issue. Radker and Harris were very outspoken pro-life, and they've changed. So why would we do that? And as a lawyer, if you were my personal lawyer in court, would you give me that kind of advice? I'm not sure. That's my question to you, firstly. Secondly,
hold on, I just have to take one question. I'm really sorry.
Multiple parts already. Sorry. On the voice, the question of voice, I think I agree with you that voice is extremely important. But I think that how we amplify our voice actually is through ordinary law. So let's remember how referenda come about. We only get a referendum when politicians give it to us. We get general elections when we bring governments down. In fact, we would have more opportunity to have our voice more frequently if that was what people thought was required and necessary through having it legislated, because every single election cycle you make it an issue. Like that, I just think that is how democracy works. And I have to say, if I were your personal lawyer, the second point, changing our mind. Sometimes we say, I don't understand why we say changing our mind, being open to maybe changing our mind on something is a bad thing. I think it's a good thing for us to be reflective and thoughtful. I'm sure that you have often rechecked your position on this. You've often checked yourself against new things you've found out, and you have maintained a position, but you have rechecked, reflected and thought, because you're a human being with a mind. I think that's what we would say should happen, really, is that people should be able to have positions that shift over time, because that is morality. I don't believe morality is a fixed thing. It's a living thing. And the very final point about if I were your personal lawyer, I don't think I would be advising you on, the best way to have, it's not the question doesn't make sense to me within the context of this question that you had asked, but I'm happy to discuss it with you separately afterwards. I don't understand what you meant by it.
Just very briefly on it, I would just add that in relation to electing the politicians and to do our will and all the rest, once they're in government, they can make a law that you mightn't like, and you won't be able to get them out of office until after the harm is done. And what I would say in relation to that is, we know that governments have been coalitions for a very long time now, and a few people with a particular view on this can hold a government to ransom on the issue. And so I must say, at this point you hold the reins. You hold all the reins. If you remove the 8th Amendment, you don't hold the reins, and politicians and the government can do what they want.
There's 5 minutes left, so I have 2 long-standing questions here, and then unfortunately I'm going to have to wrap it up. I'm very sorry, I know I disappoint a lot of people, but we'll just take those 2 last questions, and then... Okay, go ahead, very quickly, only a question.
Hello, my name is Leslie Hughes. I am Director of Sinn Féin's Repeal campaign and a member of the Together for Yes campaign as well. I'm also a proud owner of a uterus, and I am a mother of...
We can't hear you what you said.
Proud owner of a uterus, and I'm a mother of 5.
Congratulations.
3 living and 2 who are not living. Yeah, so you can stop sneaking in there if you want. I'm also... Shame on me. I'm also someone who's been affected by the 8th Amendment. Not the way you probably think. What I would like to ask is, do we matter? Do my living children matter? A woman over there said that she's totally against abortion, but she feels sorry for the people who have to have abortions. I didn't have an abortion. My baby was dying slowly inside me for 3.5 weeks. And when I asked the doctor to please tell me could I start grieving or do I get excited about this pregnancy, his answer to me, which his hands were tied, I will never blame him, I did at the time because I didn't understand. His answer to me was, it's like this, we don't want a court case on our hands. I didn't matter to him in that moment. No, because he knew the trouble he could get into. My 2 children that I had at the time didn't matter to him, one of which was only 10 months old. I wanted that baby. I would have done anything for that pregnancy to carry on. But I was left there until that baby, till those cells all completely died inside of me, left there. Risk of infection was there. Risk of my mental health completely gone, which I do suffer from mental health issues. They knew this. They left me for 3.5 weeks.
Okay,
my question is, as I said, do I matter? Do all the women who want their babies, who really got pregnant because they want to, but they can't carry on that pregnancy because the pregnancy is not viable, but they're made to hold on to it. You said that doesn't happen. It does happen. And I sat in a room with Sheila Hodder's husband 2 weeks ago while he cried and told this country that he wanted to repeal the 8th. We met him. He is totally against the 8th. His wife should not have died. Their baby died because even though they kept her alive.
Okay, we'll give Caroline a chance to...
Do we matter? Do us, the mothers, who want our babies but can't, who are being held in a hospital until that baby dies, do we matter? Do my children matter?
Okay.
Of course they matter. Was your baby delivered then when it died?
No.
I had a DNC, if anybody, you all know that.
Yeah.
It's not that you were looking for
not.
termination, that
No,
you were
I
looking
know.
for those dying cells to be removed from your body.
So the baby was removed when it
The
died.
baby was never going to be viable.
I know, I
They knew that
understand.
from the start.
And they removed the baby as soon as it died. Yeah. Okay. And in Shield Heart, and that is what is the practice now. When the baby dies, that is it is horrible, but an awful lot of people in this country believe actually that a woman has to continue to carry a dead baby around, and that you definitely don't. And you did have to wait, and it is traumatizing. 3 weeks, it's hell. I can imagine that it was absolutely awful. But that is what the law is, because we do protect all life, and we're not allowed to hasten death or cause death, either at the end of life or at the beginning of life. And compassionate care, which you didn't find compassionate, I understand that, is what is to be given. Sheila Harder's case was different in that she wasn't being given cancer treatment, which she was entitled to. And there is no doubt that she should have gotten the treatment that would have alleviated her pain and possibly given her a bit more time alive with her cancer. I don't know that a cure was a possibility there, but it was what she went through was absolute torture. There's no doubt about that. It was before the 8th Amendment came into operation, and no doctor, it was in a hospital that has come under a lot of investigation for other things too, I think for symphysiotomies and for the removal of wombs from healthy women. There was an awful lot of very bad medicine being practiced at that time in a number of places, and I think that, I hope that that doesn't happen today. Doctors do in this country have really good results. Most outcomes of pregnancy are healthy and happy ones, and we don't have the same level of maternal mortality or maternal morbidity, as in death outcomes or really bad health outcomes, as they do in the UK, where abortion is freely available. I am very sorry for this.
So the first thing I would want to say is I'm very sorry that happened to you, and that was your experience. And the second thing is that I think this does go to, which I already said, it does go to what we think we should aspire to in the way that we govern care in pregnancy. And this is, the fundamental root of the issue. We are not going to agree on this, right? That's the fundamental difference between us, right? Do we aspire to a person being alive, or do we aspire to something different to that? That has a lot to do with what we believe, with the values that we hold as individuals and so on. And the question becomes whether or not we believe that if what we aspire to is the preservation of life, and that we think that that's enough, whether we think that that is what should be in our constitution to impose that aspiration on all, or whether we think that even if that is what we aspire to, we should allow through our constitution for an aspiration that is greater, so that those who don't share our view don't have to live under it, and those who do can make those decisions in accordance with their own beliefs.
Or to answer your question, the other way of dealing with it is, if you feel, and a considerable number of people do, if you feel that in that kind of a case, where a baby isn't viable, it's pre-viable, it's not going to be born alive, and you feel that the doctors shouldn't wait until the baby dies to deliver you, then look for, I can't hear if Fiona said something there, but anyway, look for a proposal that would deal with that kind of a case, not for something that removes the right to life of every unborn baby in the Constitution. That's the one.
I don't think there's time for any more. I know there's...
That's not true.
That man has been waiting. That man has been waiting all night. He's literally... the shortest question possible, okay? The shortest question possible. And this is the last question, unfortunately.
My name is Paul Butler. Just a very quick question. We hear a lot of talk about it being a woman's body and a woman's choice. I know of a case where the guy in the girl ended up getting pregnant. They split up. She was pregnant. He begged and pleaded with her to keep the baby. Offers to support the baby, raise the baby, had the support of his family, pay all the costs, and get into it, and said to the girl, look, you can be involved in the baby's life if you want, it's your choice. But she said, no, it's my body, it's my choice, and have the abortion. What do you say to dads who find themselves in the position of wanting to keep their baby, but the woman turns around and says, my body, my choice? How do they put anything other than no in them tragic circumstances?
Okay, so I think there are... I'll try to be brief. I think there are two, but there may be three short parts to my answer. The first part is to say that with or without the 8th Amendment, the law can't do that for you. The law doesn't do that for you now. The law won't do that for you without the 8th Amendment either. Okay? That's the first thing. The second thing, which is related to that, is, what are we actually asking law to do for us here? Are we asking law to solve everything in our relationships and in our life in this area? Because I don't think law can do that. I think actually the way to resolve situations like that, which are extremely difficult, is to try to have loving and caring and respectful relationships between partners where we can talk about things properly and try to come to a decision. And the final part is that even with that, inevitably, the woman is the person who's pregnant. This is, sometimes we in these conversations, we skip to the last bit, we skip to the birth, we skip to a child. But there is also pregnancy. Pregnancy is not nothing. Pregnancy is hard. Pregnancy is your body. It is a human being growing inside you. And if you're not okay with that, if that's not something that you consider you can bear, please try to imagine what the intrusion must feel like. It's only temporary. It's only temporary, it's 9 months. Right? So so pregnancy maybe is 9 months long or thereabouts, but there is also a lifelong sort of identity. There's an issue of self, and this is about body and self and mind and consciousness, because life, we know this, life is not just being alive. Right? Life is not just being alive. Life is rich, life is complicated, life is relationships, life is people. It's complicated. So my basic answer to you is, law can't fix that. I'm sorry. With or without the 8th, law can't fix that.
Okay. Ladies and gentlemen, I want to thank you for your attention and for keeping this a civilised and respectful debate. I want to thank particularly our two speakers tonight, Professor Fiona de Londras and Caroline Simons, for their insightful and challenging responses. And I also want to thank Paul Nolan for carefully keeping a monitor on the time, although we ran over. And lastly, can I just ask you, express the hope that something that you heard this evening will be insightful when you come to vote on the 25th. Thank you all so much.